Members, we have a quorum. Let's get started. Agenda item 1, information papers issued since the last meeting. After the last meeting, the Secretariat has issued 2 information papers to members. The details are set out on the agenda issued on the 21st of April this year. Items for discussion at the next meeting. List of outstanding items for discussion. The Secretariat has already issued to members the list of outstanding items for discussion. LC paper number CB bracket 1385/2026 bracket 01. Regular meeting in May. The next regular meeting will be held at 4:30 p.m. on the 18th of May. It's a Monday. The administration proposes discussing the following items. A. Hong Kong's occupational safety and health performance in 2025. That's the first item on the list of outstanding items for discussion. B. Implementation of the subsidy scheme for abolition of MPF offsetting arrangement. That's the second item on the list of outstanding items for discussion. Do members agree? All right. Agenda item 3 of today's meeting. Enforcement of labor legislation by the Labor Administration branch of the Labor Department. I'll first invite the relevant government officials to join us. Members who'd like to speak, please press the request to speak button now. I'll first invite Deputy Commissioner for Labour to walk us through the paper. Deputy Commissioner, please. Good morning, members. Good morning, Chairman. In this item, the Labour Department will brief members on the enforcement of labour legislation by the Labour Administration branch of the LD to save employees' rights and benefits. The Labour Administration branch is responsible for the enforcement of the Employment Ordinance, the Employment Agency Regulations, as well as the Employees' Compensation Ordinance. All along, the Labour Department has adopted a multi-pronged approach to safeguard employees' rights and benefits. Through various channels, we launch publicity campaigns as well as educational efforts. We help employees understand their own benefits as well as rights. We also urge employees who suspect that their rights and benefits are compromised to reach out to us through, for example, the hotlines we set up. They could also, through online forms as well as through email and other channels, lodge complaints to us. The Labour Department is highly concerned about each complaint we receive, and we follow up on each case we receive, and we conduct investigation to protect employees' rights and benefits. Apart from publicity as well as education, and we appeal to employees to make complaints to us, we also talk to the relevant stakeholders as well as trade unions. For example, we talk to stakeholders including Consulates General in Hong Kong. We keep in close communication with them. We keep in view sectors with higher risks so that we can intervene early and to ask employers to comply with the labor legislations. We also adopt a risk-based approach to conduct inspections. For example, we visit workplaces as well as employment agencies to meet with employers and employees, as well as licensees that operate employment agencies to detect whether there are any breaches or non-compliances. On dealing with claims, as well as compensation claims lodged by employees, if we suspect that there are any breaches, we would refer to the relevant branches and divisions under the Labour Department for follow-up. Apart from protecting local workers, we also protect the rights and benefits of imported workers. Imported workers could be protected under our law. I'd like to brief members on the major policies that help protect imported workers. For example, within 8 weeks upon the arrival of each imported worker, they have to attend a briefing session held by the Labor Department to ensure imported workers understand their employment rights and benefits. Also, if imported workers suspect that their rights are exploited, they would know how they can make complaints. Last January, the Labor Department rolled out the Imported Workers Support Scheme. We provide consultation and support services for imported workers. Also, if imported workers, after their employment contract is terminated and if they need support to deal with the relevant procedure, we would offer accommodation allowances as well as food allowances to the imported workers concerned so that they could continue to file any employment claims or any complaints that they'd like to make. For foreign domestic helpers, we have a dedicated thematic portal for them. We also inspect the relevant employment agencies to make sure that they comply with the requirements. We've also introduced a code of practice for employment agencies. We ask employment agencies to comply with the relevant rules and regulations. We ask each FDH, before they report for duty, receive the information we disseminate so as to ensure that each FDH understands their rights and benefits. If they suspect that their rights and benefits are exploited, they could make complaints with us. The LD will continue to, through the various measures, continue to protect the statutory rights and benefits of employees. The above is my briefing on the work of the Labor Administration branch. We welcome any questions as well as comments from members. Thank you, Deputy Commissioner. I'm going to read out the names of the members who have asked to speak. Mr. Alvin Lee, Mr. Ken Wong, Mr. Rock Chen, Mr. Chao Xiu Chung, Mr. Kingsley Wong, Mr. Lam Chun Sing, Deputy Chair, Mr. Chen Pui Kong, and Mr. Lam Wai Kong. 5 minutes for each member, including questions and answers. Mr. Alvin Lee. This year marks the inaugural year of the National 15 Five-Year Plan, and the SAR government is going to formulate its own 5-year plan for Hong Kong. While we strive to revive economic growth, how can we protect the rights and benefits of grassroots workers? This is an indispensable part. We have to strike a balance between economic development as well as protecting employees' rights and benefits. I agree that the government needs to adopt a multi-pronged approach. At the same time, the government has to play a coordinator as well as mediator to make sure that there are good employer-employee relations. We have to, at the same time, make sure that the policies are deterrent enough. I have the following suggestions. First, on the number of cases that require follow-up so that I can better understand the trend. According to the administration paper, there are a number of figures. Take 2025 as an example. The government inspected workplaces for about 150,000 times. Summonses convicted amount to about 2,200. The number of inspections do not equal to the number of follow-up actions as well as the number of complaints. If we simply look at the number of inspections as well as the number of inquiries, well, I want to know in 2025 how many complaints were received in total. I want to know if there is an upward trend. Please provide the information if you have it with you. As mentioned by the administration, the government takes follow-up actions when a complaint is received. So what I want to know is how many complaints are received, how many investigations did you conduct, then we can have a better idea of the trend. The new arrangement of 468 has been rolled out, and there have been worries in the relevant industries about the potential impact on part-time workers. So after the launch of the 468 arrangement, are there new arrangements made by the LD to better protect employees' rights and benefits? Deputy Commissioner, I thank the member for the concerns as well as the questions. In relation to complaints, we receive complaints from employees who suspect that their rights and benefits are compromised through various channels, and we have the relevant figures under the different branches and division. I'll ask my colleague to provide the information afterwards. As mentioned, we follow up on each complaint we receive. Where necessary, we would conduct inspection, we would talk to the complainant, we would collect evidence to decide whether the employment agency or the employer concerned violate the labor laws. If there are any breaches of the laws, we follow up on the case through various means. For minor cases, we give verbal warnings. For more serious cases, we give written warnings. We make sure that the employers and employment agencies concerned would comply with the relevant laws. If we have sufficient evidence, of course, we would take out prosecutions. The member is concerned about the situation after the launch of the continuous contract arrangement of 468. After the launch early this year, we noticed that employers and employees need time to take forward their work to make sure that they comply with the law. We have done a lot of publicity work as well as follow-up actions. We stress that if employers circumvent the new 468 requirement, they may violate the employment ordinance. If we receive any complaints from employees, we would provide relevant services to help the employers and employees concerned. For employees, we would like to help them to comply with the new arrangement. As for the number of complaints, perhaps my colleague could supplement. Mr. Tony Chiu would supplement. Thank you, Chairman. On the number of complaints received under the Enhanced Supplementary Labor Scheme, the scheme was launched in September 2023. As at March 2026, we received a total of 1,048 complaints. Over half of the complaints were made in or after September last year. They cover various law enforcement agencies and different types of cases. So the government needs time to launch comprehensive investigations. As at March this year, we have completed about 280 complaint investigations. For some of the completed investigations, we have issued 89 warning letters. And for 26 cases that involve non-compliances, we have imposed administrative sanctions on 35 employers, which include refusing their applications for bringing in imported workers. We've also revoked their applications as well as refused to process any applications that were tendered after.
Mr. Ken Wong, thank you, Chair. According to the paper, the employer prosecution figures in 2025 for foreign domestic helper employers, it's 0. In Q1 of this year, there's only 1 case. I have reservations about the figures. I wonder if the figures reflect the reality. Will the government review the existing prosecution and compiling of figures arrangements? I've heard some employers say that there are foreign domestic helpers who are stealing from them, or they have some sort of financial issues. Will we have the figures for prosecutions against foreign domestic helpers? Can we also review the existing regime to make sure we can deal with cases of irregularities of foreign domestic helpers without stigmatizing them? Thank you. Deputy Commissioner. On the protection of interests of foreign domestic helpers, the Labor Department practices a multi-pronged approach. We have a specific division that deals with measures relating to foreign domestic helpers. They maintain regular liaison with the consul generals. There's also a dedicated website that ensures foreign domestic helpers can, through various ways, understand what employment rights they have, and they can lodge complaints if necessary. After working on this for many years, we have received much less complaints on wages or asking for their rights to be restored from employees, especially foreign domestic helpers. At least the situation is under control. And through our conciliation service and other existing administrative arrangements, we have been able to help employees, providing them with the assistance they need. Of course, during investigations, if there is sufficient evidence, we'll prosecute the employers. Regarding the members' concerns on other measures relating to foreign domestic helpers, what we do is, on one hand, regulate the employment agencies to make sure their services are in compliance with the relevant laws as well as the code of practice. If employment agencies do not comply with the relevant rules and regulations, we will issue an oral or written warning, and the relevant figures for conviction and number of warnings issued are uploaded onto the Labor Department's website, and citizens can look up the figures so that they know what the problematic employment agencies are for their reference. Mr. Rock Chen. Thank you, Chair. I have 3 questions. The first question is on the 5th page of the document, the Chinese version of the document. There is now an online complaint channel. Is the department using AI or various technologies to identify the urgent or serious cases so that you can prioritize investigation and enforcement resources? My second question is similar to one that is asked by a member earlier about the summons and conviction figures. There are many labor unions who have expressed to members that the figures do not reflect the reality, and it is said in the paper the Labor Department has implemented some enhancement measures. I want to ask, in future at job fairs, will the Labor Department deploy independent officers to supervise the recruitment exercise of employers so that they know why certain local employees are not hired, or they can follow up after the job fairs why qualified local workers are not employed? My third question is about the annex. On the first page, we have some summons figures. We have some company directors who are convicted. It will restrict them in future in taking up posts of directors. I want to ask if the Labor Department will work with the Financial Services and the Treasury Bureau so that we have some sort of credit regime for directors so that we can impose proper restrictions on directors in taking up posts of directors in future. Deputy Commissioner, thank you, member, for the 3 questions about complaints. For every complaint we receive, we will follow on them. We will depend on the circumstances of each case, take appropriate follow-up action. On the use of technology, we of course will consider this. We will try to make use of technology to enhance our capabilities of investigation and enforcement. The member also asked specifically about some enhancement measures we have under the enhanced supplementary labor scheme for specifically the occupations of junior cooks and waiters or waitresses. We have some job fair requirements for employers. We attach great importance to prioritizing local recruitment, and after each job fair the employers participated, the employers have to submit to us a report how many local workers they have interviewed, for example, so that we have a full grasp of the situation. We also follow up on each of the worker interviewed, whether they are hired in the end. If we find any arrangements to be unreasonable or inappropriate, we will follow up on those. And if it is confirmed that the employers have breached our rules and regulations, we will impose an administrative sanction. And members may know that we do issue press releases publicizing the names of the employers to increase the deterrence of incompliance. For serious incompliance, such as cases of wages in arrears or termination of contracts of employees or closure of companies in general, if any laws are breached, we will consider prosecuting the directors based on the evidence available to increase deterrence. On dealing with applications for the protection of wages on insolvency fund, if there are inappropriate acts on the part of directors, we will refer the relevant cases to the official receiver's office. And we have seen before some examples of the official receiver's office applying to the court to revoke the eligibility of certain directors in taking up posts of directors in future. Thank you. Mr. Cha Su-chung. Thank you, Chair. I have some questions on administrative sanctions for employers importing workers. In 2024, we have 2 cases, and in 2025, we have 22 cases. That is a significant increase. And in Q1 of 2026, we have 11 cases. If we times 4, we expect 44 cases by the end of the year. With a significant increase in the figures, does it imply that we cannot enforce effectively against incompliance? In a way, the Labor Department's punishment is not deterrent enough for employers. You will just revoke employers' eligibility in importing workers for 2 years. I mean, for employers that do not meet the eligibility criteria in the first place, there is no loss on them. They will just accept the fact that they are not allowed to import workers. It seems that it is only after the department has received complaints that the department will follow up on this, and in the past 6 months they have dealt with 280 odd complaints, and 30 odd cases have had administrative sanctions imposed. You still have 1,000 odd cases to handle. Why is it so slow? Will you be more proactive? For cases where employers are actively trying to provide false declarations, will we increase the penalties so as to increase deterrence? I want to ask about paragraph 17 in particular. We have had inspections held across the territory. In particular, we have 18 joint operations. We have, in particular, for wages in arrears cases in the construction industry, we often see news reports where workers are holding banners saying that they are not paid, and they're not paid for 2 months or even 4 months. I understand some subcontractors will ask employers to sign papers confirming that they do not have wages in arrears. When the Labor Department officers see this, would they see this as that they have not had wages in arrears? So employers have this kind of an insurance. Have you really observed such instances where workers are asked to sign such confirmation papers? Will you meet with workers to have more in-depth investigation to find out more about the situation on wages in arrears in the industry? Thank you, Deputy Commissioner. Thank you, Mr. Chow, for the 2 questions. On the enhanced supplementary labor scheme, we have some figures for administrative sanctions. With the higher numbers, it actually shows we attach great importance to the handling of such cases and how we have stepped up enforcement and follow-up action on complaints and suspected incompliance. We have 2 categories. One category is that employers have breached the labor-related laws or immigration-related laws, and they are convicted and will impose administrative sanctions. In the past year or so, we have received some complaints from local workers suspecting the employers having fired employees after importing workers, or during local recruitment fairs, the employers breach the relevant requirements of the scheme. Let me say something here. The Enhanced Supplementary Labor Scheme has some very comprehensive requirements, and if employers breach the relevant requirements and us imposing administrative sanctions, that would mean we would suspend or terminate the handling of applications from relevant employers. We believe with such administrative sanctions, it is us trying to strike a balance. The Labor Department is conducting a review on the Enhanced Supplementary Labor Scheme. One of the review areas is about protecting the interests of imported workers, as well as ensuring employers comply with requirements of the scheme, and we will also review the relevant penalties for incompliance. The member also asked about inspection arrangements. For every inspection, it will be random. After every inspection, we will inspect the records of employers, and we will meet with employees of the employers for various industries, including the construction industry, so that labor inspectors can communicate with workers face-to-face without the presence of employers' representatives to find out more about the wage situation as well as other areas of employee interests. If there is any irregularity, we will follow up on such cases. Mr. Kingsley Wong.
Thank you, Chairman. I see that summonses convicted accounts for the highest number, and that cover those who fail to take out insurance as well as wages arrears. I'm most concerned about wage defaults. Say, for example, in Q1 this year, there might just be 5 cases. We've talked to the relevant trade unions, and we understand that over the past year, we have already offered help to 190 cases involving 2,000 people, as well as $100 million. So we see that wages arrears in the construction industry is a common trend. They are not isolated cases. Thanks to the Labor Department as well as the Development Bureau and other government departments for their efforts. However, I want to point out that wage defaults in the construction industry is a systemic issue. It is a common issue instead of isolated cases. I want to know if the Labor Department will work with the Development Bureau or other departments to study how you can plug the loopholes. Now turning to the employment compensation system from 2018 to 2025, employers who died without insurance, there were about 24 cases, and there are cases involving FDHs as well as construction workers. Also, the penalty level is low. Those who breach the relevant legislations are subject to a fine of $100,000 and an imprisonment of 2-year terms. However, most are only sentenced to a $2,500 fine or even $25,000 fine only. If the fine level ranged between $2,500 and $25,000, I think the penalty level was too low. If the upper ceiling is $100,000 and a 2-year imprisonment in future, how can you ensure that you can increase deterrence and make sure that there are tougher penalties? Also, for industries that fail to take out insurance for employees, how do you deal with the situation? Deputy Commissioner, the member asked 2 major questions on wage defaults in the construction industry. Again, the Labor Department is highly concerned about the situation. Of course, we will regularly work with the relevant departments, including the works departments under the Development Bureau. We will continue to exchange information and intelligence with them. In relation to wage arrears in the construction industry over the past year, there are various reasons that caused the situation. For example, the problems involve service agreements between the principal contractor as well as the subcontractor. Also, it could be because there were problems with the cash flow of the subcontractors concerned. We continue to keep in close communication with the Development Bureau as well as the relevant departments to see how we can regulate the problem at source and that we could urge the principal contractors as well as the subcontractors to make sure that the workers working on their construction sites could get their pay in time. When there are disputes between employers and employees, we would work with the relevant trade unions as well as the relevant departments to provide conciliation services in hopes that we could resolve the disputes as early as possible. The member also asked about failure of employers to take out insurance for employees. Our labor inspectors conduct inspections, and sometimes during the inspections, they find that their employers failed to take out the insurance or that the insurance taken out by the employers have already expired. And also for businesses that have just been started, they failed to take out insurance for their employees in time. And after our investigation, the employers concerned would take rectifications and take out effective insurance as early as possible. And these cases do not involve workers' injury cases. We understand that there are work injuries and employees could get injured. And if the employers concerned failed to take out insurance for the injured employees, we would follow up on these non-compliance cases. We also keep in view the sentences given by the court. If we realize that the sentences given by the court is too lenient, we would talk to the DOJ to see if there's a need on our side to apply for a review. We understand that for cases involving work injuries and the employers failed to take out insurance for employees, the penalty level should reflect the severity of the cases. We would continue to monitor the data and the sentences given by the courts. Mr. Lam Chun Sing, I am concerned about the shift from the 418 arrangement to the 468 requirement. For some companies, they may employ a worker for no more than 67 hours in order to circumvent the requirement. I am most concerned about the workers who are already working under the original system. You said that around 11,000 workers would benefit from the new arrangement, and a lot of them worked for about 100 hours per month. In the past, for the fourth week, they only needed to work for 17 hours. Therefore, they failed to meet the 418 arrangement. However, after the switch to the 468 arrangement, they would be able to fully meet the requirement under the new continuous contract requirement, and they should be able to enjoy more benefits. If they have to work fewer hours to 67 hours because their employers needed to circumvent the requirement, would you follow up on these cases to see whether, for example, it is stated in their written contracts that they should work for at least 100 hours every month, or whether they made any verbal commitment to allow the workers to work for 100 hours per month, and if they deduct the number of working hours of their employees to 67 hours, it might be the case that the employers were breaching the contract. So I want to know if you have done anything to learn about the latest situation. I want to know if you could be more proactive in this regard. Also, some members asked about wage arrears. Last August, the compensation arrangement for construction industry were officially launched. And the launch of the scheme was to make sure that construction workers could be paid in time. I want to know if after the legislation took effect, you made sure that workers were given their pay from the foreman. If that's the case, that means the subcontractors have money to pay their workers. Have you reviewed whether after the launch of the Construction Industry Security Payment Ordinance, there were any wage defaults? Or was it that the ordinance actually didn't help mitigate the situation, and that wage defaults continued to exist? Deputy Commissioner, I thank the Deputy Chairman for the members. In relation to the point about the new continuous contract requirement, the new arrangement helps plug the loopholes that we faced in the past, and also it helps lower the threshold for workers who worked for fewer working hours so that they could get the benefits and rights more easily under the employment ordinance. We noticed that there are workers who get their benefits and rights, including holidays, under the new continuous contract requirement, and they did not get such benefits in the past. We understand that workers or employers are happy to pay for these benefits and rights under the new requirement. However, we understand individual employers might make new arrangements for their employees after the new requirement is imposed. They might adjust the working hours of their employees. I agree that if there are such cases, we could step up our efforts in learning about the situation. We believe that employers who try to circumvent the new arrangement and therefore reduce the number of working hours of their employees, this is very undesirable. We should understand why such a situation happened, because this could have a negative impact on the employers, including their image as well as reputation. So if there are such cases, I agree that the Labor Department should learn about why the employers did so that we could provide our advice to the employees concerned so that they could make rectification under the new requirement. Also, the member is concerned about wage defaults in the construction industry. As mentioned, we work with the Development Bureau, the principal contractors, as well as the relevant stakeholders. We also conduct inspections and provide conciliation services to deal with wage default cases. Over the past year, we noticed that in the first half of 2025, wage arrears were more common in specific projects, and that could be because of the closures of certain contractors. From the second half of last year to Q1 this year, our observation was that there was a reduction in the number of wage arrears cases in the construction industry. It could be because there have been more construction projects lately. It could also be because we launched the Construction Industry Security and Payment Ordinance. However, we will not stay complacent. The construction industry is one industry that we will continue to pay attention to, and we will continue to liaise with the Development Bureau to understand and learn about how contractors and subcontractors are dealing with the pay of the workers after the ordinance took effect. Next, Mr. Chen Pui-kong. Thank you, Chairman. I have a couple of questions. First, I'd like to ask about the new 468 arrangement. Just now, the administration said they would launch extensive publicity campaigns. Has the administration launched any targeted inspections? If the administration did, were there any irregularities or non-compliances detected? For example, were there any employees who tried to split the contracts of their workers or circumvent the new requirement? And how did you follow up on these cases? Second, there are some complaint figures in your paper. You got 1,048 complaints, and you only followed up on some 280 complaints. And that is not very effective because you only followed up on 1/3 of the complaints. Are there more effective means for you to take follow-up actions on these complaints? Third, the DAB did a survey, and according to our survey, 40% of the respondents said employment agencies committed malpractices. For example, abetting their the candidates to engage in improper practices. So we have suggested the administration to step up regulation and introduce a scoring system. Will the administration take on board our suggestions? Will you set up an open scoring system on the thematic portal? Will you consolidate the records of employment agencies violating the relevant rules and regulations?
Some for me.
Deputy Commissioner, thank you. Chair, Mr. Chung asked questions in 3 areas. On continuous contracts, the labor inspectors take a risk-based approach when planning for inspections. For each inspection of labor inspectors, they will enforce the employment ordinance, and they have comprehensive understanding of the employment ordinance on wages, leave, days, as well. They will also ask the employers and employees to find out about the employers conduct based on the employment ordinance to see if there is any unreasonable or inappropriate work arrangement. If we have received complaints from employees, we follow up on each and every case, and we collect intelligence to take follow-up action if necessary. We talked about earlier about handling of complaints of enhanced supplementary labor scheme. We attach great importance to handling of such complaints. As one of the officers said, most of the complaints were received in Q4 of last year, and some cases involved other government departments. We are closely working with the different departments in enforcement. We are also reviewing the complaint handling mechanism to see how we can enhance efficiency. On regulation of employment agencies, we have actually adopted many suggestions made by members before. We have already set up a particular division for the protection of foreign domestic helper interests, as well as regulation of employment agencies. We are more or less providing one-stop service for the specific areas. On ensuring compliance by employment agencies of the code of practice as well as relevant laws, we have adopted a multi-pronged approach. We will issue oral and written warnings. If there is adequate evidence, we will initiate prosecutions. We have already announced the figures for conviction cases as well as cases in which we have issued written warning. These are cases that are more or less confirmed because we have already a conviction record or issued a written warning. As for how we can tell people about the service performance of employment agencies, we really need to carefully consider the situation. We need to make sure things are objective and are handled fairly, and we want to also minimize disputes. We will explore different appropriate options of trying to do this. Thank you. Mr. Lam Wai Kong. Thank you, Chair. I have several questions. The first question is on inspections. We note for the figures in the past 3 years, we have over 100,000 inspections conducted. I want to ask how many of such inspections are proactive inspections and how many of the inspections are surprise inspections. I think if all of them are random or surprise inspections, that would be ideal. So I want to find out more about the situation. About workers reporting employers, many of them are very worried. For anonymous reports or complaints, will the department deal with those differently? compared to those who have themselves named. Third, on enhanced supplementary labor scheme, we have approximately 1,048 reports, and the department only followed on 287 of the cases. How much time is needed approximately to handle each case? Would the department consider deploying more manpower in conducting inspections and taking follow-up action on such reports? Since the launch of the Enhanced Supplementary Labor Scheme 2 years ago, we have now different labor importation schemes for different industries. Some workers are unfortunately illegal workers, and for employees it's hard to distinguish between legal workers and illegal workers. Would the department be able to provide more information on workers employed by employers to see what posts they're in for employees and labor unions to really monitor the situation? Now, for wages in arrears, if it is charged as a criminal offense, the maximum penalty is $350,000 in fine and 3 years imprisonment. And we have not really heard any cases in which the maximum penalty has been handed out. Would we consider increasing penalties to increase the deterrence, or would the department apply for a review of cases in which the sentence is relatively light to increase the penalties handed out? Deputy Commissioner, thank you. Mr. Lam asked about several areas on inspections. We are already implementing enhancement measures to step up inspections, and we have our inspections in the form of surprise inspections. We also meet with employees to have better understanding of their employment situation. We deal with anonymous complaints the same way as we deal with those who name themselves. We wouldn't pay less attention simply because the complaint is an anonymous one. We do welcome anonymous complaints, and the complainants can make a decision on whether to name themselves. On complaints in relation to the Enhanced Supplementary Labor Scheme, most of the complaints were received in the past few months, especially in Q4 of last year. We need some time to follow up on the cases and coordinate the relevant departments in investigation. Our target is to handle each complaint as soon as possible and complete the investigation. We will review the arrangements to see if we can work more closely together with other departments on investigation and complaint handling. But it also depends on the complexity of the specific case. We do not have specific information on how much time is needed to handle each complaint, but please rest assured we do want to complete the investigation for each and every complaint as soon as possible. On penalties relating to wages in arrears, we attach great importance to combating cases where employers are trying to shirk their responsibility in payment. We have seen employers being handed out a prison sentence or a community service order before. We will see how we can enhance publicity on the harsh punishment for wages in arrears. For example, there is potentially a prison sentence. And if we see in court cases the sentence is excessively light or inappropriate, we will work with the Department of Justice to see if we can lodge a review of the sentence. Thank you. Mr. Xu Kaofei. Thank you, Chair. I want to ask about the inspection and prosecution figures in the annex. I want to ask how much an establishment is there in the Labor Department for frontline inspections? Deputy Commissioner. Thank you, Mr. Xu, for the questions. We have 2 divisions for conducting inspections. We have the division for employment agencies as well as the labor inspection division. I will ask perhaps the supervisors of the 2 divisions talk about the manpower and relevant arrangements. I'll first ask the supervisor from the labor inspection division to speak. I only need information on the manpower. Thank you, member, for the question. We right now have 200 odd officers, labor inspectors specifically, conducting inspections from the labor inspection division. All right, I will now ask Ms. Ruby Chu from the Employment Agencies Administration branch to speak. For the division, we have labor officers 1 and 2 conducting inspections. In terms of establishment, we have 10 or around 20 officers conducting inspections. Thank you. Thank you, Chair. I can see in the annex 2023, 2024, 2025, we have every year approximately 150,000 inspections, and if we divide that by 365 every day, they would conduct approximately 400 inspection visits. They have approximately 200 officers handling such work, and I believe their workload is quite heavy as a result. I can see for the conviction figures in page 2 of the annex, in 2023 construction industry, we have 142 in 2023, 2024 137, 2025 94, and in Q1 of this year we only have 5 cases. We do see a declining trend. I believe that is like the Deputy Commissioner said, the industry has been warned. We also see in the F&B and wholesale retail industry seeing a declining figures. However, for financing, insurance, real estate, and business services, we have seen the figures increasing. In Q1 of this year alone, we have 62 cases. Has the department reviewed why we have seen an increasing number for the particular industry sector, while there is a decline in other industry sectors? Deputy Commissioner. Thank you, Mr. Xu, for the questions. Mr. Xu mentioned specifically the convicted summons figures. For financing, insurance, real estate, and business services sector, in the past few years, we have seen 152 cases in 2023, in 2024, 196, in 2025, 189. There are different factors that go into the numbers. For example, during inspections and enforcement operations, if we have adequate evidence, we will initiate prosecution. But another factor is the court may have different arrangements for hearings for specific cases. There are different factors that go into the fluctuating figures. We will, however, pay close attention to the situation in the industry and have specific plans for enforcement strategies. Thank you. Any follow-up questions, Mr. Xu? Yes, I do, Chair. We have often heard news reports on wages in arrears in the construction industry, but from the specific figures, we do see higher numbers for financing, insurance, real estate, and business services. We really need to pay close attention to the situation. Chair, if you allow it, I want to take some time to talk about some of the comments I heard recently. We have heard many friends say there is a rampant situation of illegal workers. They would go to different shops to ask to be hired as, say, dishwashers, and restaurants because they have a manpower gap and they don't know much about the situation. They breach the law inadvertently. I hope that we can combat the situation. I can see that the department has been working hard in conducting inspections, but I actually recently met with a boss of a company and a director, and apparently directors, they have to take tests on ESG, and apparently a lot of them fail, so they don't know much about ESG. The labor legislation is actually quite complex. Is it possible for the Labor Department to provide training to companies, personnel, senior personnel of companies, so that they will pay more attention to the issue? And if we can expand the arrangements to different companies, it will definitely help with inspections, because if senior personnel what labor laws there are, they will try to provide better protection for their employees. Thank you.
Deputy Commissioner, we're highly concerned about the situation with illegal workers. Under the lead of the Security Bureau, we have established an interdepartmental task force to step up our work on combating illegal workers. We also agree that we should strengthen education as well as publicity efforts. Under the Labor Department, we have 18 HR committees, and we encourage chambers of commerce to work with us to study how we can step up education and publicity on combating illegal workers. Next, Mr. Chen Chou-Kwong. According to the administration paper, the administration has conducted a lot of inspections and has taken out prosecutions. It proves that the administration has done a lot of work, but we should not simply look at the prosecution figures. For a lot of wage default cases, the final penalty given by the court is not significant for the non-compliant companies. So my question is, over the past 3 years, on average, what is the fine imposed on each non-compliant cases that are involved in wage defaults? Also, apart from strengthening inspections, are there any specific strategies? For example, has the administration considered imposing tougher penalties, and also will there be a higher threshold for company directors to be convicted? Deputy Commissioner, on conviction figures as well as prosecution figures, I'll see if my colleague could supplement. I share the same view as the member. We are highly concerned about any serious breaches or wage default cases. We have increased the penalty once to $350,000 for the highest penalty and a 3-year imprisonment under the employment ordinance. We've had various cases for more serious breaches in which employers were put to jail immediately for 44 weeks to 4 months. For those who are involved in wage offenses, we will see how we can impose tougher penalties on them. We will keep in view the situation, and at the same time, for serious cases that involve a high number of employees where wages were defaulted for a longer time, we would provide relevant information to the courts so that the courts could refer to the information as they hand down the sentences. We will also talk to the DOJ to see if we could take follow-up actions. As for the number of summonses convicted, I'll see if my colleague will supplement. Yes. In relation to the number of summonses convicted, for those that involve wage arrears from 2023 to Q1 2026, the highest sentences imposed by the court was $174,000 of fine. For those that defaulted on awarded payment of the Labor Tribunal, as well as the minor employment, the MECAB, the penalty was $100,000 approximately of fine. Mr. Woon-kit. Paragraph 6 of the administration paper says the LD adopts a risk-based approach. And for the construction industry, the cleaning industry, as well as the security guard industry, they were most serious. In 2025, the number of inspections were highest in the financial sector as well as real estate and insurance sector, but they are not the industries that involve the most serious wage default. So I want to know how the administration distributes its resources to reflect the risk-based approach. And also, can you tell us the number of inspections you have conducted as well as the number of convictions for our reference, so for us to gauge whether the enforcement efforts were effective? Also, according to the paper, in 2024, there were about 663 convicted summonses in respect of wage offenses in 2025, which represents a huge drop compared to 2024. This shows that the administration's effort was effective. However, some wonder if the employers concerned would still be prosecuted or convicted if the employees affected were unwilling to come forward to testify against the employers. So how many such cases were there which led to a failure of convicting the employers? Deputy Commissioner, I thank the member for the two questions. To respond to the question about the number of convicted summonses in respect of wage offenses, we did not adjust the threshold in relation to our evidence collection as well as prosecution work. We try our best to collect evidence and take out prosecutions in each of the case we handle. As for the number of convicted summonses, in the previous year there was a drop due to various reasons. The number of complaints we received could be one factor. And also to explain to members, there is also a lag in the number of convicted summonses. We have to wait until the court completes the entire judicial proceeding. Then we can include that number into our table. Last year, depending on the progress of the court case, as well as the court's arrangement, some of the convicted cases could not be reflected in last year's statistics. for for cases involving wage offenses, if the employer concerned choose to defend themselves, we ask employees affected to come forward to testify against their employers. We therefore encourage employees to work with us in our investigations as well as the court's proceedings. In individual cases, because of various reasons, the employees concerned might be of the view that the arrears of wages had already been settled, and therefore they chose not to testify against their employers in the court. Regardless of the employee's choice, we would try our best to put the non-compliant employers into justice. And also, we take into consideration various factors when we adopt the risk-based approach. I'll ask Mr. Ho to tell you more about our arrangement. I thank the member for the questions. We adopt the risk-based approach as we allocate resources to our inspections. According to figures, it looks like for the financing, insurance, real estate, and business services, we deployed more resources. This is because the breakdown is rather broad here. Apart from financing services, for example, under real estate services, cleaning workers as well as security guards are also under the real estate sector here. It is about how we include the breakdowns here. Any other questions? If not, we thank the officials who attended this item. Agenda item 4. Processing of applications to the Protection of Wages on Insolvency Fund in 2025. I first invite the relevant government officials to join us. Members who'd like to speak, please press the request to speak button now. I'll first invite Deputy Commissioner for Labour to walk us through LC paper number CB-1385/2026-04. Deputy Commissioner, please. Thank you, Chairman. In this item, we brief members on the Labour Department's processing of applications to the PWIF Protection of Wages on Insolvency Fund in 2025. PWIF is established under the Protection of Wages on Insolvency Ordinance. The purpose is to provide ex gratia payment for employees affected by business closures of their insolvent employers. According to the above-mentioned ordinance, there is the PWIF board that's responsible for administering the fund. The Wage Security Division of the Labour Department acts as the PWIF office. Currently, the PWIF covers arrears of wages, wages in lieu of notice, severance payment, pay for untaken annual leave, and pay for untaken statutory holidays for employees. Under the abolition of offsetting arrangement, employers may be unable to pay severance payment to employees upon the abolition of using the accrued benefits of employers' mandatory contributions. Therefore, we're concerned that some employers may not be able to pay the severance payment to their employees. So we have proposed raising the payment ceiling of the severance payment under PWIF to enhance the protection of employees affected by business closures. And the latest ceiling took effect starting from March last year. The payment ceiling was raised from first $100,000 plus 50% of any excess entitlement to first $200,000 plus 50% of any excess entitlement. We last year received some 5,800 applications, up 14% compared to the previous year. And the number of release of ex gratia payment was 5,500 cases approximately, involving $267 million, up 18% and 8% respectively compared to the previous year. In order to shorten the time to process applications, starting from November 2022, we started to engage law firms to provide free legal service to assist applicants in filing winding up or bankruptcy petitions against the employers, to save applicants the time and effort to apply for legal aid and go through the means test at the legal aid department. At the same time, in April 2023, under the Labor Department, we formed an in-house legal team so that Commissioner for Labor could exercise discretion to release ex gratia payment even though there was no winding up or bankruptcy petition presented. The PWIF keeps streamlining the process to speed up the processing of applications. From November 2022, the PWIF office has set key performance indicators in handling PWIF applications. As at December last year, the PWIF office has met all the relevant KPIs, and the Labor Department is highly concerned about any abuses of the PWIF, and we have set up an interdepartmental task force comprising representatives from the Labor Department, the Commercial Crime Bureau of the Police Force, and the Official Receiver's Office to strengthen investigation of suspicious cases. The PWIF is mainly financed by the annual levy on business registration. As at December last year, the balance is about $7.24 billion, so it is in a healthy financial position. The above is my briefing on the PWIF.
Thank you, Deputy Commissioner. We have 4 members who have pressed the request to speak button. Mr. Lim Chun Sing, Mr. Chiu Kao-fei, Mr. Chao Siu-chung, and Mr. Lam Wai-kong. We have ample time. I will assign an 8-minute time limit, questions and answers included. Mr. Lam Chun Sing, Deputy Chairman. Thank you, Chair. The PWIF was launched 40 years ago. It has helped employees get their wages even when their employers, who are not deliberately accumulating wages in arrears but are insolvent. The fund will help the employers pay some ex gratia payment. I have concerns, however, about the ex gratia payment of the fund, whether there is some adjustment mechanism. We have 10 odd years ago included leave days in the calculations. There has not been reviewed since. However, for a severance pay ex gratia payment, we have made an adjustment in 2022, and thereafter there was another adjustment. It seems that the government is pretty much just all over the place. So can you set up a regular review mechanism, say every 5 years you review the financial position of the fund and whether workers are able to get their wages in arrears in full with ex gratia payments from the fund, or whether there is a need to adjust the business registration levy. We should have a regular mechanism to review these every 3 or 5 years so that we won't have something like this where we have not seen any changes in 20 years and it's still at $36,000. Of course, we have seen some increases over the years, but there should be a regular review mechanism. As the Deputy Commissioner said, most of the cases involve employers claiming insolvency. But then for employers hiring less than 20 employees, there is discretion that can be exercised by the the Commissioner for Labor to disperse ex gratia payment. And I can see with the number of employees, the cases covered, most of them have 20 to 49 employees, or for SMEs in general, the number of employees is 20 to 49. So can we increase the cap for the number of employees so that we will have more covered by the arrangements that employees can receive the ex gratia payment faster? But of course, we need to make sure the department plays the gatekeeper role to prevent abuse. After all, the discretion lies with the commissioner, so is there room for some relaxation? Thank you. Deputy Commissioner, thank you. Chair, thank you. Deputy Chairman for the 2 questions. About the coverage of the PWIF, the Labor Department and the PWIF Board are closely monitoring the situation. They do review, for example, as the Deputy Chairman said, the financial position of the fund, as well as the ex gratia payment arrangements for employees, whether the payments paid to them can cover fully the wages owed by employers. We have seen in the past certain cases, because legal proceedings were ongoing, there was a period of suspension, and indeed it would take more time to handle such cases. We will review the relevant cases to see if there's a need to adjust the coverage. We do have some flexibility. For example, last year with the abolition of the MPF offsetting arrangement, we have reviewed the arrangements relating to severance pay, which is why in a relatively short time we have made adjustments to the ceiling of the severance pay ex gratia payment. I do understand the concerns of the Deputy Chairman. The PWIF Board is actually supervising the operations of the PWIF, and they do have in close view the circumstances surrounding the fund's operations and whether there's a need to adjust arrangements relating to ex gratia payments, including the coverage. We will closely monitor the situation with the assistance of the PWIF Board on coverage as well as relevant arrangements. The Deputy Chairman also raised concerns about the current requirement that with a company with less than 20 employees, even without a petition being made by them, the employees can receive ex gratia payments still. But of course, as said by the Deputy Chairman, we have to prevent abuse, which is why we have this threshold of 20 employees in law. And if the employer has more than 20 employees, they must have a winding up or bankruptcy petition. We want to make sure the PWIF will not become an ATM for people to withdraw money. We believe with the current threshold, we have struck a balance, but we keep an open mind. We will review relevant data as well as previous experience to see if this threshold needs to be adjusted. Thank you, Chairman. Any follow-up from the Deputy Chairman? Well, not really. I just want to say that with the PWIF, we do not have a review mechanism, a regular review mechanism, just like the minimum wage, where we have to have a review every 2 years. But I hope that with the coordination between the Labor Department and the PWIF board, we can do something. I just wanted to raise relevant concern. Thank you. Mr. Xiu Kafai. Thank you, Chair. The PWIF is established to provide a safety net for employees affected by business closures of their insolvent employers. If the companies have tried their best but can do nothing else but to shut down their business, there's nothing you can do. We do have the government trying to make payments instead, but we have to be prudent. In Table 3, it seems that the top 3 industry sectors with the highest numbers of applications approved by the PWIF every single year, the construction industry is one of the top 3 industry sectors. So I want to ask if the administration has conducted studies to see if there are any duplicate applications from the same group of people or directors. Thank you. Deputy Commissioner, we attach great importance to preventing abuse of the PWIF. We do practice a comprehensive approach. For example, we'll look at employees to see if they have made previous applications. For employers, we also look at our records to see if in the past when they closed their businesses, there were some malpractices or inappropriate conduct. If necessary, we will follow up on relevant cases through the Interdepartmental Task Force. Any follow-up, Mr. Xu? Yes. In Table 1 and Table 2. Well, let's look at Table 1 first. The number of applications received by the PWIF. We had only 2,889 cases in 2021, but 5,842 cases in 2025. So the figure has more than doubled. And if we look at Table 2, the number of applications approved by the PWIF and the amount of ex gratia payment granted, I don't really understand. Say for 2023, in Table 1, we have 3,293 applications received. Why is it that in 2023, for the number of applications approved by the PWIF, there are more cases than the number of applications received at 3,545 cases? Thank you. Deputy Commissioner, thank you. I have some supplementary information to provide. For the number of applications, it relates to the number of employees. So in 2021, we had 2,889 applications received. That means 2,889 employees applying to the PWIF for payment. We will follow the relevant laws and regulations. while expediting the handling of applications, trying to meet fully the relevant performance indicators. We have at some point received applications with the PWIF office receiving the applications. Apart from following the legal procedures, they need to verify past records of employees and employers and then disperse payments to the employees. There is a bit of a time gap, so sometimes we have figures reflect number of applications received earlier in the previous year. Thank you, Chair. I now understand. So for the number of applications received, they are apparently on an employee basis. How can we know how many companies have closed or resulted in the applications made to the PWIF? Deputy Commissioner, thank you. All along, we practice an employee basis for the number of applications in our data to reflect the relevant changes in applications. We can look at that, the specific figures. I think if we only do the calculations on an employee basis, we may not be able to conduct comprehensive analyses. If you can provide figures on how many companies are involved, I think it would provide a clearer picture. For some larger companies closing down, we may already have 2,000 odd employees affected. I think it will really help us gauge the market situation with relevant data being provided. So I think the Deputy Commissioner can provide in future figures about how many companies are closing down and which industries they are from. It shows that perhaps these companies are shirking their responsibilities and let the PWIF shoulder the burden. I also said earlier we have seen between 2021 and 2025 the number of applications received more than doubled, and we have to understand after the Black Clad violence, businesses are faced with great difficulties and some businesses have to undergo transformation. I believe this is just a transient period. With more visitors, we should see a recovery. I hope that there will be less businesses closing. The accumulated surplus of PWIF stands at $7.2 billion. And I'm actually not quite concerned about the number of applications received by PWIF doubling between 2021 and 2025. I think it's just the economic situation. But I'm worried with the abolition of MPF offsetting arrangements. Some employers do not have to shoulder relevant payments for MPF. Some employers are not making the necessary contributions, and if they don't do much, the company's burden will be shifted to the PWIF. This is what I raised before when we discussed the abolition of the MPF offsetting arrangement. We may not see such cases at the moment, but I hope the Labor Department will be monitoring the situation closely. We have $7.2 billion. It's a lot, and I would like to just have this kind reminder for people.
Deputy Commissioner, I thank Mr. Peter Chiu for the comment. The first comment is about reflecting the number of employers involved. We will look into this in future when we come back to report to members about the operation of the PWIF. If possible, we would provide the number of enterprises or companies involved. I also agree with the point about the abolition of offsetting arrangement. We will keep in view after the 1st of May when the abolition of offsetting arrangement took effect. we will keep in view the situation. For example, the number of applications we receive, as well as the expenditure. We thank Mr. Peter Xu for the comments. Any follow-up questions, Mr. Xu? No. Mr. Chao Xiu-chung. I'm looking at paragraph 8 of the administration paper about key performance indicators. There are 2 KPIs. First, the PWIF office strives to release ex gratia payment within 3 months for simple and straightforward applications. And 2, they strive to release ex gratia payment not more than 6 months for 90% of non-disputed and substantiated applications. And the PWIF office has been meeting the KPIs in 2024. 99% of the cases saw release of payment within a few months' time. Within a few weeks' time. I want to know if you start counting the processing time from when you receive all the required documents from the employee. However, for employees, it takes them a few months for the entire process. I want to know if you can provide information showing from when employees submit application to the PWIF office to when they get the ex gratia payment. How long does it take? For arrears of wages alone, I hope you can speed up the progress of releasing ex gratia payment for employees. This is because it's easier for you to define when there are wages in default. For other items, there might be easily disputes, but for arrears of wages, there are no disputes, and this has to do with the living of employees. So can you come up with a KPI just for dealing with applications involving arrears of wages so that employees affected could maintain their living? Second, about preventing abuse of the PWIF. Over the past 2 years, in 2024-25, the number increased significantly. In year 2024, the number of increase was 55%. There were some 3,000 cases. And in 2025, the number further increased and up some 40% compared to 2024. With the abolition of the offsetting arrangement, employers will have to start paying severance payments to their employees. And so there might be greater incentives for employers to abuse the PWIF. In the past, we only had to deal with applications concerning arrears of wages as well as wages in lieu of a notice. So there weren't that many incentives for employers to abuse the fund. However, with the abolition of the offsetting arrangement, there could be greater incentives. According to paragraph 10 of the paper, the Labor Department would keep in view whether any employers are involved in illegal transfer of assets. I want to know if the officers under the Labor Department could detect such cases. I remember about 20 years ago, the PWIF were faced with lots of challenges, and the Labor Department mounted an operation. Back then, the Labor Department hired retired police officers who were experienced with dealing with commercial or financial crimes. And those retired officers were given the power to take part in the operation. Now, with the surge of the number of cases, I want to know if the officers under the Labor Department have the capacity to detect any fraud cases or anyone who is suspected of abusing the fund. Deputy Commissioner, I thank the member for the questions. Now, paragraph 9 of the administration paper provided some figures on how the PWIF office managed to meet the two KPIs. On the first KPI for simple and straightforward applications, well, our KPI is that we should release ex gratia payment within 3 months' time for these applications. About 60% of the cases are regarded as simple and straightforward applications, and for these cases, we were able to release ex gratia payment within 2 months' time. As to how we define simple and straightforward applications, one factor we consider is whether these cases involve arrears of wages. For cases that only involve arrears of wages, they are regarded and defined as simple and straightforward applications. And according to our KPI, we release the ex gratia payment within 3 months' time for these cases. As for the second KPI, we hope to release ex gratia payment not more than 6 months for 90% of non-disputed and substantiated applications. According to our statistics, about 70% of these cases saw release of ex gratia payment within 4 months. So overall speaking, we will continue to review the processing of applications. We'll explore if we can put in place measures to further shorten the processing time. Now, turning to the point about combating abuse of PWIF, we will pay attention to situations where businesses are closed down. Given the abolition of the offsetting arrangement, we will convey this concern to the interdepartmental task force. For companies suspected of illegal transfer of assets, we refer the cases to the Commercial Crime Bureau of the Police Force under the Interdepartmental Task Force for investigations. As for those who are suspected of violating the employment ordinance, like in the past, we are still hiring retired police officers to help with the relevant investigation work. Mr. Cha Xiu-chung, any follow-up questions? I would like to follow on the point about the two KPIs. As the Deputy Commissioner said, some take 3 months and some take 2 months for the office to deal with the applications. So how do you count the time you need to complete the processing? Because that would affect whether there is room for you to further streamline the processing time. Also, you said that for cases only involving arrears of wages, they would be defined as simple and straightforward applications. However, for other cases that involve arrears of wages as well as, for example, other items, would you also single them out and regard them as simple and straightforward applications so that the affected employees could get the ex gratia payment as early as possible? Deputy Commissioner, we start counting the processing time from when the PWIF office receives the application. You mentioned about 6 weeks and 8 weeks. I think those KPIs were set previously. The two KPIs mentioned, they were introduced recently. Now, with reference to the two latest KPIs, we will keep in view how we managed to meet the targets. Now, on the other comment made by Mr. Cha Xiu-chung, I totally understand where the member is coming from. for applications involving arrears of wages as well as other items, we thought about whether to regard them as simple and straightforward applications so that we could streamline the procedure. If we only single out the item of arrears of wages and release the ex gratia payment for the arrears of wages first, it might end up taking longer. Also, we have to consider whether this arrangement would be appropriate for affected employees. So we did take these into account in the past under the Labor Department. Where appropriate, we would review the processing arrangement again. As for whether there is further room to shorten the processing time, we will look into this. Thank you.
謝主席。
Mr. Lam Wai-kong. Thank you, Chair. About the PWIF, I think one major area is offering protection. We do not have adequate protection in relation to wages in arrears, as some members said. For the construction industry, if they are owed wages for 3 and 4 months, and each month their wages would amount to $30,000 with the $80,000 cap, they cannot recover the full amount of the money owed to them. So I hope that there can be upward adjustment on the ceiling. Also, is it possible to enhance the coverage of PWIF to cover those who have not had their MPF contributions made? We have quite a solid balance right now, $7.2 billion for the PWIF. There is room for us to enhance coverage for workers. Next, on preventing abuse, we do see more businesses closing due to the economic situation. However, the significant increase cannot be explained away by this alone. We do expect certain incompliant employers abusing the mechanism. Right now, if one breaches the relevant law for the PWIF, the maximum penalty is just 3 months imprisonment. And apparently, enforcement or prosecution will often be made under other laws such as the theft ordinance or crimes ordinance through interdepartmental operations. If we need to have the Labor Department refer the cases to other departments, it may take long. Is it possible to just increase the penalties of the PWIF ordinance to increase deterrence against abuse? We do not have much publicity on what penalties were handed out to incompliant employers. I'm not sure if it is because the employers were prosecuted under other ordinances such as the crimes ordinance. I just want to ask if there is any plan of the administration to review the penalties to combat abuse. We have seen quite good figures for applications. I want to also say, however, some workers said it is hard for them to make digital applications, so they have to take leave even when they are in a difficult position. Is there some way to simplify the procedures so as to make it easier for the workers to make digital applications? Thank you. Chair. Thank you, Mr. Lam, for the questions. About the application figures and approval figures, we do keep in close view of the figures to see if we have excessively low figures for different categories such as wages in arrears, payment in lieu of notice, and severance payment. The recovery rate is 85% to 90%. If we see a significant deviation, the PWIF board will, in a timely manner, activate a review. As for what Mr. Lam talked about, MPF contributions not made by employers, if employers did not make MPF contributions while deducting such contribution payments from employees' salaries, the PWIF would cover such instances. With employers not making MPF contributions, this is different from the cases in which employees are owed statutory benefits under the employment ordinance. And with employees having their contracts terminated under the employment ordinance, the PWIF wants to provide a short-term financial relief to employees. It is different from the MPF scheme. The PWIF works to provide short-term relief to employees, whereas the MPF scheme provides long-term retirement protection for employees. We did consider the situation, and we have no plans at the moment to expand the PWIF to cover MPF contributions to be made by employers. We do understand Mr. Lam is concerned about potential abuse of the PWIF. We do make good use of the interdepartmental task force. What's good about the interdepartmental task force is that we will have different departments working together to review the different cases and having exchanges to make sure there is no delay in investigation and enforcement. For cases mentioned in the paper, for example, the illegal transfer of assets or frauds, there are specific ordinances targeting the different offenses. I believe it would be better if we leave it to the respective enforcement agencies in handling such cases. We do try to keep up with the times with the procedures. Right now, with the Labor Relations Division, it accepts digital applications. People no longer have to attend centers in person to submit information. We will keep in close view of the situation to see if we can enhance the arrangements for submission of information. Thank you. Any follow-up from Mr. Lam? If not, the meeting was supposed to end at 12:45. Let me first extend the meeting by 15 minutes up to 1 o'clock. Mr. Holden Chow, thank you, Chair. I want to ask about Annex 1. We can see 2025, we have seen a significant increase of applications from the construction industry. It's about double. In 2024, the figure was 746. In 2025, it's 1,375. So it's close to double the figure in 2024. The PWIF works to offer protection for employees so that when a company closes, there will still be protection for employees. But with a higher number of applications to the PWIF, it is not exactly good for society. We may interpret the figures to say a lot of companies are closing. We actually want there to be a lower number. I want to in particular focus on the construction industry. Does the department have any idea why there is a significant increase in the number of applications from the construction industry? A lot of industries are related to the construction industry. Maybe what is not good for the real estate industry can also affect the construction industry. I am concerned the PWIF may be encouraging businesses to close down and people to apply to the PWIF. If businesses are resilient and can survive the difficulties, wouldn't it be great? I think in particular the construction industry is different from other companies in other industries because there are cycles. For the contractors that have a good financial position and with government support, they will be able to really survive. And I think with government support, the firms can stay in business and they will create job opportunities. I'm not sure if it relates to the financial situation last year. I'm just not sure if everyone really needs the assistance of the PWIF. We don't want to see high numbers, as I said earlier, of applications to the PWIF. This is not a good thing. We want businesses to be resilient. We want businesses to be doing well. Thank you. Deputy Commissioner. Thank you, Chair. Thank you, Mr. Chow, for the comments and questions. Mr. Chow's analyses are quite on point. For the construction industry in the past 1 or 2 years, we have seen some adjustments to the number of projects in the sector, especially of the private sector. The number of works projects available will directly affect the cash flow of firms. We have seen contractors of relatively long history and of quite a large scale closing down. Of course, there are different reasons why the businesses have closed down. And we have seen some wages are owed with the chain in the construction industry. We do keep in close view of the situation. We see the situation in the construction industry improving. We do not see as many labor disputes in the industry, or at least preliminarily, there is a decline. We hope this trend will continue. But let me say this. Even if an employer's business is suffering and has to close down the business, employers need to try their best to pay their employees. It's not just with the employees applying to the PWIF. Employers will be able to circumvent the requirement of paying their employees. If we have seen some irregularities, we can still prosecute the employers or directors. All right, I will have Mr. Lam Chun-sik speak for a second round.
關注嗰個
Chairman, I am concerned about the coverage of the PWIF. Last year, the PWIO was amended, and the ceiling of SP payment was raised, and it was said that the coverage should increase from 86 to 91% after the amendment to the ordinance. I want to know if the Labor Department has the latest statistics showing the coverage of the ex gratia payment under PWIF. I want to know if employees are earning more, and therefore, even with the higher ex gratia payment, it would not be able to cover the amount they lost. So if that's the case, could the $80,000 ceiling be adjusted upward for arrears of wages? Deputy Commissioner, I thank the Deputy Chairman for the questions. Last year, we raised the payment ceiling of a severance payment, and it started to take effect on the 21st of March last year. That means the latest payment ceiling of severance payment would apply to any employment contracts that was terminated on the 21st of March last year or onwards. And the adjustment of ceiling would benefit employees with longer years of service that are supposed to get a higher severance payment. We will continue to keep in view the situation. Affected employees who need the PWIF would have to first apply to the Labor Relations Division. And it might take time for us to make observation concerning these application figures. If there's more time for us to make the observation, the figures we obtain would be of higher reference value, not just for severance payment, but the other items covered by the PWIF, including arrears of wages, wages in lieu of notice, and pay for untaken annual leave. Our thought is that we will have the the latest term of the PWIF board to review the latest coverage of the ex gratia payment first. Then we will decide whether we should further adjust the payment ceiling of the other items. Agenda item 5, there being no further business, meeting adjourned. Thank you.